Yes, so I want us to start with the questions from Cat 1. From that Cat 1, which has got how many questions? 6 questions. And then maybe from there, we can move to the other paper. So we go straight to question number 1. Question number 1. So what are we told in that question number 1, part A? Or actually, question 1, it reads, Janet and Jackson Onyango are forming a registered company. Remember, registered company, we said, is that particular company which will be formed and also registered in accordance with the Companies Act of 2015. So they want to form a registered company. They are seeking your legal advice on the issues listed below. So respond to the inquiries by Janet and Jackson on number 1. What are the memorandum and also articles of association, and is there any difference between the two? So in that case, what was basically required there is explanation of what is MOA and also what is AOA and the differences between those two documents. Remember, you said that MOA and AOA, these are constitutions of the company. These are documents which contains the rules and regulations of of the company. So therefore, in that case, the candidate basically were required to explain memorandum of association and also articles of association and their differences. And they are what? They are differences. They are what? They are differences. So first of all, we said that MOA, Memorandum of Association, this one we said is an external constitution of the company. Is an external constitution of the company. Why? Because it contains rules and regulations which governs the relationship between the company and outsiders or between the company and third parties. So therefore, we can say that it is the company's external constitution, external constitution, since it contains rules and regulations, which governs the relationship between the company and third parties. And who? Third parties. So it governs the relationship between the company and third parties. So basically, this document here contains rules and regulations on how the company will be dealing with third parties. That's why we are saying it is basically what? It is an external constitution. On the other hand, articles of association, we said that this one is an internal constitution. It is the company's internal constitution, since it contains rules and regulations, which basically governs the relationship between the company and its members, its members. So this current document, which contains rules and regulations on how the company will be dealing with its members. If, for example, the company wants to convene a general meeting, so how should that be done? If, for example, the company wants to make a call on shares, how should that be done? If, for example, a member wants to transfer the shares, how should that be done? So this basically governs the relationship between the company and its members, and therefore it is an internal constitution. So what are the differences between these two documents? Are there differences between these two documents? Yes, we said we have basically a number of differences between MOA and AOA. We have a number of differences between these two documents, MOA and AOA. And some of the differences which exist, number one, we said that this one is an external constitution. This is an external constitution, whereas this is an internal constitution. This one is an internal constitution. That is basically the first difference. So the other difference, we say that the content of this document here are basically clearly defined under the Companies Act. What about the content of this document? The content of articles of association, we said, is not defined under Companies Act, but it's something agreed upon by the members. So therefore, we can say contents, or its contents, that is, its contents are what? Are defined at the Companies Act. At the Companies Act. Whatever is to be contained in this document is something which is defined under the Companies Act. What about AOA? We have said its contents are agreed upon by members. Are agreed upon by who? By members. Whatever is contained here is something which is agreed upon by who? By the members of that company. So the other difference between these two documents, we say that this document here cannot be easily altered, cannot be easily amended, because we said any amendment which is to be done to this document, it has to be done clause by clause. Each clause has to be amended separately. And actually, we look from the various the requirement of altering various clauses, which are also different. So we can say it can't be easily altered. It can't be easily what? It can't be easily altered. Whereas this one, we can say it can be altered. It can be altered easily. So it is basically to alter this particular document, we say it is quite simple, because we said various clauses can be altered, can be basically be amended by passing a single resolution. By passing a single what? By passing a single resolution. By the members passing a single resolution there. Yes. So those that is basically the difference number 3. Then we can talk about number 4. Number 4, we can say that this particular document here, that is AOA, we say that this one is basically subordinate to the Companies Act. This one is subordinate to the Companies Act. Basically, we say that once a company has been registered, a company needs to comply to a number of rules and regulations. Those rules and regulations, some of them are contained under the Companies Act. The Companies Act is actually regarded to be the supreme source of rule to the company. Below that, we have MOA, and then below that, we have AOA. That's why we are saying this one is below Companies Act, but the AOA, this one we said, is basically subordinate to both MOA and also what? And also the Companies Act. And also the Companies what? The Companies Act. The Companies what? Act. Yes, I think those are basically some of the differences between those two documents. So that is what was required as far as the part A of that question is concerned. So let's move to part B. Part B, we are required to explain to Janet and also Jackson the restrictions upon the choice of the corporate name with which a promoter must comply with. Remember, we say that whenever the company is to be registered, we talked about those individuals who come together to form a company. Actually, we refer to them as promoters. The founders of the company, we refer to them as promoters. Promoters, or basically a promoter, we said, is a person who undertakes to form the company with respect to a given project and set that company as a going what? Concern. We said whenever the promoters are basically forming the company, we talked about various duties which they should undertake. And those duties, we said, are broadly classified into two: the fiduciary duties and the general duties, or the common law duties. We talked about, I think, 3 fiduciary duties: the duty of the duty to account, the duty to act bona fide, and the duty of disclosure. Those are the 3 fiduciary duties. Then we talked about the various general duties, or the common law duties, like coming up with the name of the company, registering the company with the registrar of companies, meeting or paying the preliminary expenses, also maybe appointing the first directors of the company, acquiring the asset for use by the company, and so on. So we said those are the general duties of the promoter. So therefore, what the question was asking here is the restrictions regarding the choice of the name. The restrictions regarding choice of company's what? Name. restrictions regarding the choice of the company's name. Remember, in this case, we said, whenever you want to register a company, basically you must come up with at least 3 names, because we say that some of the names may be rejected. So you must come up with a number of 3 names. But equally, we said whenever you're coming up with those particular 3 names, there are those restrictions which are imposed regarding the choice of the name. So that's why you may come up with certain names, and those names are rejected. So which restrictions are imposed regarding the choice of the name? Number 1, we said the name should not be too similar. The name must not be too similar to that of an existing company. Should not be too similar to that of an existing company. Otherwise, if you come up with a name which is too similar to that of an existing company, that name cannot be reserved. Number 2, we say that the name should not include a registered trademark. The name should not include a registered trademark of another company. Should not include a registered trademark of what? Of another company. In this case, I gave good examples here. If, for example, you want to come up with the name of the company, so you cannot include a registered trademark. For example, you cannot come up with a name like M-Pesa Company Limited. You cannot come up with a name like what? Like maybe Samsung Company Limited. You cannot come up with a name like iPhone Company Limited, because all those names, Samsung, iPhone, M-Pesa, those are registered trademark of other companies. So the name should not include a registered trademark of another company. So number 3, we said the name of the company, the name should add with the word limited. Should add with the word what? Limited. Anytime you're coming up with the name of the company, make sure that that name includes the word what? Limited as the last word. Number 4, that is, we said the name should not be misleading. The name should not be what? Should not be misleading. The name should not be misleading. Otherwise, if the name is misleading, for example, in this case, I said, if, for example, you are to come up with a name and maybe you include the word international, maybe XYZ company or XYZ International Company Limited. By including the word international, basically, that implies that this could be a company operating in a number of countries. If that is not the position, the name is actually regarded to be misleading. On the other hand, we say that the name should not show connection. Should not show a connection with a government department, or even the president. The government department or who? Or the president. Or who? Or the president. Equally, we say that the name of the company should not include an abbreviation which is not permitted under the Companies Act. Abbreviation not permitted under the Companies Act. On the other hand, we said that the name of the company should not show some criminal intention. Some criminal what? Intention. So therefore, these are basically some of the restrictions regarding the choice of the company's what? Name. Regarding the choice of the company's name. Also remember, in this case, we say that once the company come up with a certain name, and basically that particular name has been registered, we say that a particular name can be changed at any time due to a number of reasons. And actually, in that case, we talked about, we look on the requirement of the Companies Act for the company to be able to change the name. So we talked about passage of a special resolution. And then from there, we said the MOA has to be amended. And then we say that the 2 documents, the copy of the special resolution, the amended MOA, they must be forwarded to the registrar of companies. We talked about with 21 days or 14 days for the registrar to be able to do what? To give his approval. We talked about 14 days, 14 days, Yes, I think we talked about 14 days. Those 2 documents must be forwarded to the registrar for the registrar basically to peruse them and basically check whether the requirement of the Companies Act have been complied with. If they have been complied with, then we say that he will issue the company the certificate of the change of the name. And we say the company can proceed and start operating with the new what? Start operating with the new name. So part C, of the question. Part C, we are told the registers and documents that are normally kept at the company's registered office. Registers and document are kept at a company's registered office. Company's registered what? Office. Now remember, we say that the company's registered office, this is basically the company's head office. And actually we say that the company's registered office is basically a place whereby most or actually important documents of the company are kept, and also the statutory registers. Statutory registers, basically we said, are those particular registers which the company is required to do what? To compile and basically keep at its registered office at the company's act. So therefore, here we can start by looking on the statutory registers. Which registers is the company required to compile and basically keep at its registered office? So we have a number of registers here. For example, we have the register of members. The register of who? The register of members. Number 2, we have the register of charges. We have the register of who? Charges. Number 3, we have the register of company directors. Register of company who? Directors. We also have the register of company secretary. Register of company secretary. That is basically the other register. The other register is the register of what? The register of what? The other register which should be compiled and kept at the company's registered office. So we talked about so many registers here. Can you give me the other register? We also talked about the register of beneficial owners, the register of beneficial owners, the register of beneficial owners. Yes, we also have the register of beneficial owners, beneficial owners. Yes. So this, I think we said, are some of the registers which must be prepared and kept at the company's registered what? Office, among others. So also we talked about the documents, some documents which must also be kept at the company's registered office. So which are some of those documents? One we said is a certificate of incorporation. The certificate of incorporation. Number 2 we said is the MOA and AOA. MOA and what? AOA, or basically a copy of the same. Number 3, we talked about what? We talked about audited financial statements. Audited financial statements. So then number 5, we have minutes. Minutes of what? Minutes of AGM. The minutes of what? Of AGM. So basically, these are some of the important documents which must be kept at the company's registered what? At the company's registered office. At the company's registered office. So basically, that is it. That what was required there. That is basically what was required there. So I want us to move and we go to the other part, and I hope you're together up to that point. Are we together up to that point? Abdinasil, Aran, Catherine, Martin, are we together up to that point? And the rest of the team, are we together up to that point? Yes. So let's move to question 2. Question number 2. So in question number 2, it reads, we are told, the court and also the statutory provisions have provided justification for ignoring the fundamental principles of legal personality through the so-called doctrine of lifting the veil. So we are required to discuss. So in other terms, what you're required to do here is, first of all, we discuss what is basically lifting the veil of incorporation. And also, because the question has got 12 marks, we explain some of the instances, some of the circumstances when the veil of incorporation may be what? May be lifted. So we talked about something called the doctrine of of what? Of rifting, or in other terms, piercing the veil of incorporation. The veil of what? The veil of incorporation. The veil of what? Of incorporation. Now, in this case, when talk about veil of incorporation, remember what we said. Once a company has been registered with the Register of Companies, the company is actually regarded to be a separate legal entity. A company is actually viewed to be separate from its members, from its directors, and also from that is from shareholders, directors, and also employees. But we said the number of instances whereby that separate legal personality of the company may be ignored, and the company is actually viewed to be one and the same with its directors, or the company is viewed to be one and the same with its shareholders. So those circumstances where the separate legal personality of the company will be ignored, and the company is viewed to be one and the same with its members, its directors, we refer to that as what? Lifting the veil or piercing the veil of incorporation, because we said a veil is like a shell which separates the company from its members. That is a shell or a shield. But we said piercing or lifting, it basically means that this particular shield has been lifted, has been removed, and actually the company now is viewed to be one and the same with its members and also its directors. Sasa, yes. So the first thing you needed to do here is basically to give that explanation. You explained what you mean by what? What you mean by lifting the veil, the veil of what? Of incorporation. What do you mean by that, Sasa? And I've said in very simple terms. So this basically or basically this entails ignoring the separate legal personality of the company, as illustrated in the case of Salmon versus Salmon and Company Limited, and therefore the company is viewed to be one and the same with its members and also with its directors. That's what you mean by lifting the veil of incorporation. Then from there, you also need to give those particular circumstances when the veil of incorporation may be lifted. And actually, we say that those circumstances whereby the separate legal personality of the company may be ignored, we say those circumstances or instances are classified into two. One, we talked about the statutory provisions. We talked about the statutory provisions. So when talk about the statutory provisions, these are the various circumstances under the company under the various provisions of the Companies Act, whereby the separate legal personality of the company has been ignored. Which are those circumstances? Which are those particular instances? Number one is in case of group accounts. In case of group what? Account. And also this is something you know from financial reporting. So anytime you have a parent company and this parent company has a subsidiary, now for the purpose of preparing the group accounts, this is basically what we did in a file. For the purpose of preparing the group account, we ignore the separate legal personality of these two companies. And actually we said the parent company and the subsidiary are viewed to be one and the same. And that's what you could see in the topic of group account. We were combining similar items of asset, liabilities, revenue, and expenses, those of the parent, those of the subsidiary. So therefore, according to the Companies Act, whenever the parent company is preparing the group account, the separate legal personality of the parent and the subsidiary is ignored. Number two here, we talked about something called the reduction of number of members. And actually, in this case, we say that if the number of members reduces below the statutory minimum, and basically the company operates for more than 6 months without the required minimum number of members, then we say that those particular debts which will be incurred by the company after 6 months shall be taken to be the debts of those who are members of that company, and they were aware of the fact that the company didn't have the required minimum number of members. Yes. Number three here, we talked about something called the misdescription, or maybe the omission of a company's name. Omission of company's name. So basically what we said is that anytime, for example, you are an officer of a company, or for example, you're a director of a company, maybe you're signing a legal document on company's behalf, make sure you have noted in that letter where you have signed that you are signing on behalf of the company. You are signing as an agent of that company, such that if the content of that legal document are breached, then you are not the person to be held personally liable. So the person, or actually the company, should be held personally liable and not you. You just signed as an agent. But if you fail to make it clear that you are signing on company's behalf, or you make it clear that you're signing on company's behalf, but you fail to include the full name of the company, then in case the content of that document are breached, you are the person to be held personally liable. You are the person to be held personally liable. So then here we also talked about something to do with a takeover bid. A takeover bid, remember, this is something we discussed in details in the topic of corporate restructuring. And actually we say that this whereby a company which is called the predator, which makes an offer to buy majority of the shares or all the shares of the company which is called the target company. The target company. So we said that once that offer or basically bid, the offer or bid has been approved by the shareholders and also the board of directors of the target company, basically those two companies are viewed to be one and the same. One and the same. So we also talked about investigation of company affairs. Number 5, we also talked about the investigation of company affairs. Remember, in this case, we said investigation of company affairs. This whereby a person who is called an inspector is actually appointed by the court to come and investigate how the affairs of the company are being conducted. We talked about the various grounds which can make the court to appoint an inspector upon application by various parties. So we said this application to the High Court for an inspector to be appointed can be made by the AG, Attorney General. It can also be made by the members of the company. It can also be made, I think, by who? It can also be made, I think we also talked about another party. So once the inspector has been appointed to come in and investigate the affairs of the company, we say that if the company to be investigated is apparent, then the inspector may ignore the separate legal personality of the parent and that of the subsidiary, and actually he go ahead and investigate the affairs of the subsidiary. So if he is investigating a subsidiary, he can go ahead and investigate the affairs of the parent. So therefore, during the investigation of the company affairs, the separate legal personality of the parent and that of the subsidiary can actually be what? Can actually be ignored. Can actually be what? Be ignored. So also we talked about now, remember these are statutory provisions, and we say that these are the various circumstances under the various provisions of the Companies Act 2015 when that separate legal personality of the company may be ignored. Then from there, we also talked about the case law, or basically the common law, provision. So basically we say that this whereby the separate legal personality of the company has been ignored, or actually is ignored at the various decisions which have been made by the courts. So the courts in the past have decided in number of circumstances, the separate legal personality of the company should be ignored. And I think we talked about a number of such instances. One, we talked about group enterprise. Group enterprise, we said, as per the rulings which have been made by the court in the past, then always the parent company and the subsidiary should be viewed to be one and the same. So number 2, we talked about the determination of companies' residence. Determination of companies' residence. In this case, we said for the purpose of determining the residence of the company, then the separate legal personality of the company and those of the directors shall be ignored. The company shall actually be viewed to be the same with its directors, because essentially we said a company is a resident of the country in which management and control is exercised. So if, for example, you have a company which is operating in Kenya, this company operates in Kenya, but we assume that this company is managed from a different country, is managed maybe from a different country, is managed from, for example, from one of the East Africa country, is managed from TZ. So it basically means that for the purpose of determining the actual residence of this company, what will happen is that the separate legal personality of the company will, and that of the directors will be ignored, and therefore this company shall be regarded to be a resident of Tanzania. Shall be, or in Kenya, essentially, this company shall be regarded to be a non-resident company because it is a resident of the country in which management and control is exercised. So a company is managed by the directors, and therefore, if the directors reside in TZ, all the board meetings are done there, then the management and control of that company is exercised in TZ. So it's a resident company there. In Kenya, it is a non-resident company. Then from there, we also talked about something called enemy character. Enemy character. And basically, we say that enemy character, this whereby majority of the shares or all the shares in a company are basically held by a person who has been declared an enemy in the country. So a person can be declared to be an enemy in the country, either because that person is a threat to the country, he has committed maybe a capital, a very big criminal offense in the country, so he may be declared to be an enemy. Automatically, a person can only be declared to be an enemy. So if that person is not a Kenyan citizen by birth, there is no way you can be declared to be an enemy of the country whenever you are a citizen by birth. So if maybe you have a foreigner who has been doing some business in Kenya, but maybe he has committed a certain capital offense, such a person may be declared to be an enemy to the country. And therefore, we say if such a person holds a majority of the shares, or basically all the shares in a certain company, then those companies owned by that person shall also be declared to be an enemy of the country. We say in such a case, the court can move and order for the closure of those companies, order those companies to stop operating in Kenya. So I think that's essentially what was required. And we said that if you peruse through the past papers, we say that this is a very, very common question, whereby you're required to explain what you mean by rifting or piercing the veil of incorporation, and also you're required to discuss these circumstances, these instances whereby the separate legal personality of the company may be ignored. And you discuss that under the two categories: statutory provisions, case law, or the common law provision. So therefore, this is basically something you need to understand. If you happen to come across a question from that, make sure you can comfortably answer that question there. Yes, so then still in part question 2, part B, we request to explain various ways in terms of how the promoters may be remunerated. Ways of remunerating who? A promoter. Ways of remunerating who? A promoter. Ways of remunerating a promoter. Ways of remunerating a promoter. Now, remember, you say that a promoter essentially here is basically a person who is undertakes to form the company with respect to a given project and basically set that companies are going concerned. Now, we said before the company is incorporated, the company lacks capacity. The company lacks capacity to enter into a contract with a promoter, that the promoter will be rewarded, will be remunerated after the company has been what? After the company has been formed. And therefore, in this case, we said that the promoter is not entitled to any remuneration from the company. But we said there are various ways in terms of how the promoters may be rewarded for their services. May be rewarded for their services because they are the founders of the company. How can they be rewarded for being the founders of the company? We talked about so many ways. Number one, we said they can be rewarded in terms of being issued with the founder, or basically the deferred shares. Founder or the deferred shares. Remember, you said deferred shares. These are the shares which are issued to the founders of the company, who are the promoters. Number two, we said promoters can also be rewarded by being appointed the first directors of the company. They can be rewarded by being appointed the first directors of the company. Number 3, we say that they can also be rewarded by being paid a commission. Being paid a commission for issuing shares on company's behalf. On company's what? Behalf. They can be paid a commission for issuing shares on company's what? Behalf. Number 4, we say that the promoters can also be rewarded by being allowed to sell an asset to the company. They can be rewarded by selling an asset to the company at a profit, provided they disclose the profit they made. So as a promoter, you can sell an asset to the company at a profit, provided you disclose how much profit did you made from that word, a transaction. How much profit did you made from that word, transaction? On the other hand, we said still, they can also be paid a commission for facilitating a transaction. Facilitating a transaction between the company and a third party. Between the company and who? A third party. So therefore, these are basically some of the various ways in terms of how the promoters may be rewarded, among others, because also we said the promoters can also be rewarded by being issued with the shares of the company at their par value after the market price has done what? Has increased. They can also accept a cash payment from the directors, but once the company has been what? Has been formed. So therefore, we talked about those various ways through which now the promoters can be rewarded for their services. Can be rewarded for their services. Can be rewarded for their services. So that is it. We are done basically with question number 2. So we move to question number 3. Question 3, part A. It reads, Mr. and Mrs. Matata intend to form a company, to form a limited company known as M&M Hardware Limited. They approach you and seek your advice. So you're required to advise them on the following issues. Roman 1, what is the meaning of a private company according to the Companies Act? And Roman 2, what explain the advantages of forming a private company as opposed to what? To the public. So Roman 1 of the questions here, basically you are required to explain what is the meaning of a private company. What is the meaning of a private company? In other terms here, you are required to give a definition of a private company. Definition of a private company. Remember, you said that this company is actually defined under the Companies Act. I think we talked about section 10, if I'm not wrong. And we said that a private company, we can say that this is a company which by its articles of association, basically which by its articles, number one, we said restrict members' right to transfer share, members' rights to do what? To transfer shares. It basically restricts members' rights to do what? To transfer shares. Restrict members' rights to transfer shares. Restrict members' right to transfer shares. Number 2, we said it is prohibited. It is prohibited from inviting members of the public. Inviting members of who? Of the public to do what? To subscribe its shares, or basically what? Debentures. So this company is prohibited from inviting the members of the public to subscribe. To subscribe is to buy its shares, or basically it's what? It's debentures. And finally, number 3, we said it's basically a company which by its articles of association limit the number of members to 50. Limit number of members to what? To 50. So in other terms, the number of members in this company cannot exceed 50. Cannot exceed what? 50. That is the definition. That is the definition. So if you happen to come across this question, don't give the characteristics. You say that a private company has got one director. No, give the definition as per the Companies Act. Sasa, give the definition of this company as per the Companies Act. Yes. So then Roman 2, what we are required to do is we explain what are the advantages of forming a private company over a public. So in other terms, the question was asking about the advantages of a private company over public company. Over public what? A company. So in this case, we said there are a number of advantages. There are a number of advantages associated with a private company over the public. Which are those advantages? Number one, we say that a private company can be able to commence business upon incorporation, or can be able to commence business upon receiving the certificate of incorporation. Remember, you say that for this other company that is a public, for it to commence business, it has to get something called a trading certificate. So therefore, we can say that a private company can commence business upon incorporation. Upon what? Incorporation, i.e., upon receiving certificate of incorporation. Upon receiving certificate of incorporation. Number two, we can say that this private company just require one person to be formed. In other terms, we say it requires one signatory to the MOA for it to be registered. The other company that is public, it requires a minimum of 7. It requires a minimum of 7. You can say it requires one signatory, to MOA, one signatory to MOA to be formed. To be what? To be formed. That is basically the other advantage. The other advantage of this company. So it basically means that to form this company is quite simple, because just one person is required. The other company requires a minimum of 7. So the other advantage of this company here, we said it is not required to hold an AGM. To hold an AGM. It is not required to hold what? An AGM. It's not a requirement under the Companies Act that a private company has to hold an AGM for its members. Remember, you said that a public company has to convene an AGM for its members on an annual basis. We said there are a number of disadvantages associated with that. One, if a company is to hold an AGM, we know that there are some costs which will be incurred by the company. The company has to send notices to the members. That is a cost to the company. The company must have a venue for that meeting. So if the company does not have a hall, the company may be required to hire a hall for that AGM. And also the other logistical costs of ensuring that the meeting is held as planned and everything goes on as planned. So many logistical costs which will be incurred. But if the company is not required to hold that meeting, those costs will not be incurred. Those costs will not be what? Those costs will not be incurred. And I think we also said that this company here, private company, we can say is not subjected to publicity requirement. Is not subjected to publicity requirement. What does that mean? It basically means that this company is not required to make its document to make information available to the members of the public, like a public company. A public company, remember, is a company which has issued shares to the members of the public. Most of the information of that company must be made public, must be made available to the members of the public. Its financial statement, after they have been audited, they must be published in some of the local dailies and so on. But this company is not subjected to those publicity requirements. It's not required to publish its financial statement, and most of its information will not be available to the members of of the public. Now, basically, that is what was required as far as that question fair is concerned. That is what was required there. Now, I want us to just take a short break. We come back and finish on question number 3, B, and C, and maybe we move to the other questions. So let's just take a short break of 10 minutes, and then we come back at 9:15, so that we continue with the other questions. Sasa, yes, so see you after the short break. We continue with the other questions. Yes, so let's continue. We continue with our revision. We continue with our revision here. And I want us to move to this question number 3, part C. Question number 3C. So what are we told there? What are we told? What are we told? Let's open that question. Yes, so the question reads, explain the rule in force versus 𝗪𝗪𝗧, making clear the purpose and the rationale behind the rule. And the rationale behind what? The rule. So the rule in force versus who versus 𝗪𝗪𝗧 versus 𝗪𝗪𝗧 versus 𝗪𝗪𝗧. So what does the rule state, and basically what is the rationale, or basically what is the purpose of this particular rule? Now, number one, this particular rule here, it can also be known as the proper preemptive rule. The proper preemptive rule, it can also be known as the majority rule. So maybe first of all, you can say that this rule is also known as the proper preemptive rule, or majority rule. Majority what? Rule. And basically, you can be able to recall, we said that this particular rule here states that if a civil wrong has been committed to the company, or a civil wrong has been done to the company, then the company is the proper plaintiff. It is the company which cannot. It is only the company which can be able to go to a court of law, take a legal action against the defendant, or against now the person who has committed a particular wrong to the company. So meaning that the shareholder or shareholders of the company cannot go to a court of law and basically take a legal action against such a third party who has committed that particular civil wrong to the company. So basically, the rule states that the rule states that when a civil wrong is done to the company, a civil wrong is done or basically committed to the company, comma, the company is the proper plaintiff. The company is the proper plaintiff. The company is the proper plaintiff. The company is the proper what? Plaintiff. So meaning that it is only the company which can go to a court of law and take a legal action against that particular third party. The members of the company, the individual members of the company, do not have any right to move to the court of law, take a legal action against who? Against such who? Against such a third party. Against such what? A third party. Sasa, yes. Now, what is the rationale behind this particular rule? The rationale of the rule, or basically what is the purpose of this rule? What is the purpose of this rule? I think we talked about various purposes of this rule. Number one, we said this rule is basically meant to avoid multiplicity of the cases. We can say it's avoid It avoids multiplicity of cases. In other terms, this particular rule is meant to avoid whereby we have so many cases which are instituted in a court of law. Multiplicity of what? Of cases. It is basically meant to avoid situations whereby we have so many cases which are instituted in a court of law, because we have said, if, for example, a civil wrong has been committed to this particular company, and, for example, individual members are allowed to go to a court of law and basically take a legal action against that particular party, we may be having different members who are going to different courts to take a legal action against that particular third party. So by the end of the day, we will have so many legal cases which are instituted in different courts by different members. So to avoid that, we are saying once a civil wrong has been committed to the company is a proper plaintiff. It is only the company which can go to a court of law, take a legal action against that particular third party, but individual members cannot be able to do that. So to avoid a situation whereby you have so many cases. Number two, we also talked about, we said that it is meant to do what? To avoid ignoring the what? The concept, or basically the principle of a separate legal personality. Separate legal personality. So it is basically meant to avoid ignoring that concept, that principle of a separate legal personality. Separate legal personality. Remember, in this case, what we said, once a company has been formed, a company becomes separate from its members. So therefore, once we have a civil wrong which has been committed to this company, is that civil wrong committed to the members of the company? Automatically no. So therefore, if the members then will be allowed to go to a court of law and take a legal action against that particular party, what the court will be allowing here is ignoring the fact that the company is separate from its members. That's why the court here rules that, made it very clear that once a wrong has been committed to the company, that is not a wrong to individual members. So individual members cannot go to a court of law, take a legal action against who? Against that particular third party. Against that particular third party. Against that particular third party. So that is basically the other rationale, or basically the other purpose of this rule. And I think number three, the other purpose of this rule is we can say it emphasizes on the majority rule. Majority what? Majority rule. What does that mean? What does that mean? We said there are some instances whereby a civil wrong may be committed to a company. A civil wrong may be committed to a company by a third party, but basically majority of the members in this company, the majority of members in that company passes a resolution that the company will not take a legal action, that the company will not take a legal action against that particular third party. Now, if that is the case, then the court of law will not intervene, because we said decisions in a company are made by majority of the members. By majority of the members. So therefore, if, for example, one of the members decide to go to a court of law, take a legal action against that particular third party, the court will not intervene, because majority of the members have already passed a resolution that the company will not be going to a court of law to take a legal action. So even if now an individual member decides to go to a court of law, take a legal action against that particular third party, the court of law will not intervene. Will not do what? Intervene. And due to the fact that a decision has been made by majority of the members that the company will not be taking any will not be taking any legal action. So that's what the rule states, and basically those are what? Those are basically the purpose or the rationale behind that rule. So the last part of that question, that is the part C, it is asking about the exceptions to the rule. The exceptions to the rule. So when talk about exceptions to this rule, we are referring to those circumstances whereby an individual member, or basically a number of members, can go to a court of law and take a legal action, against a third party who has committed a civil wrong to the company. So which are those circumstances whereby that a member or members can go to a court of law, take a legal action against that party. Number one, we talked about violation of members' individual rights, members' individualhood. Right. So meaning that if the civil wrong which is committed to the company amount to violating the right of the individual rights of members, then the members whose rights are being violated can go to a court of law, take a legal action against who? Against that particular third party. Against that particular third party. Then we also talked about illegal what? Illegal act. So if maybe whatever has been done to the company is something which is illegal, then this particular rule does not apply. Any person can go to a court of law and take a legal action against that particular that party who committed that wrong to the company. So we also talked about what we refer as the fraud on minority. Fraud on minority. Fraud on who? On minority. So if the civil wrong which is committed to the company amount to what is called fraud on minority, then the minority shareholders who are being affected can equally go to a court of law, take a legal action. Then we also talked about breach of directors' duties. Breach of directors' what? Breach of directors' duties. And basically we say that this whereby the directors are breaching their duties. For example, they are acting negligently. So we say that in such a case, the members of the company can go to a court of law and basically take a legal action against those particular directors. Against those particular directors. So I think that basically what is required as far as that question is what is concerned. As far as that question is concerned. Yes. So let's move to the other question, which is the question number 4. We move to question number 4. Yes, and I hope you can be able to recall all these concepts. I hope you have started revising. Take into account now we have, how many weeks do you have to sit for this paper? Catherine, how many weeks do you have to sit for this paper? Are they 3 or 2 weeks? They should be 2 weeks. They should be 2 weeks. I think from now. Are they 2 weeks? Yes, they should be around 2 weeks there. Or basically 2 weeks and some few days. So, and I hope you're doing a lot in terms of revision. I hope you're doing a lot. I hope you are doing a lot in terms of revision. So, question number 4. So, question number 4, we are told that the principle of corporate legal personality is an important and a fundamental aspect of a company law. Discuss this statement, citing relevant decided what is the principle of corporate legal personality. So in other terms, what the candidates were required to explain here is this principle, or basically the concept of a separate legal personality, and basically you cite a decided case plus a decided what? Plus you cite a decided what? A decided case. So basically here, for you to be able to earn those particular marks, it is important for you to know how to answer this question. Number one, you must first of all expound or basically explain what do you mean by this principle concept of a separate legal personality, and then from there you must support that with a decided case. Now, we said this principle of the separate legal personality, the principle of separate legal personality. Basically, this state what? This state that once a company has been registered with the registrar of companies, the company becomes a legal entity, which is basically separate and also distinct from its members and also its directors. So that's why we say that the company now, once the company has been registered, the company has the capacity to own property, the company has the capacity to enter into contract, the company can sue or be sued, and so on, simply because the company is actually separate from its members and also its directors. So this states that once a company is what? Is registered by registrar of companies, registered by registrar of companies, it becomes a legal entity. It becomes a legal entity, separate and also distinct from its from its members, and basically from its directors, from its members and also its its directors. The company becomes a separate legal entity from its members and its directors. That's why the company can sue or be sued on its own name. The company can own property and so on. And then you also need to support that with a decided case. And actually, you can say that this was decided. This was decided. So this was the ruling which was made. This was decided in the case of who? In the case of Solomon versus Solomon and the company limited. The case of 18 what? Is it the case of 1897? Yes. The case of 1897. And actually in this case now you can proceed and you give some facts of this case. And we said whenever you are giving this particular case, the fact of a case, you don't have to give word by word. As per the notes which you have, we just need to remember the fact of the case. So remember, in this particular case here, the case of Solomon versus Solomon and Company Limited, what happened is that Solomon here basically formed a company with the family members. He formed a company together with the family members, the wife, the daughters, and also the sons. So after forming that company, so Solomon sold his business. He had a boot manufacturing business. He had a business which was concerned with manufacturing of boots. He sold that business to that company. So after selling the business to that company, he was paid by being issued with the shares, having a value of 20,000 sterling pounds. And also he was paid by being issued with the debentures of 10,000 sterling pounds. Now, after that, this company operated for some time, but due to some challenges, the company was liquidated or to be liquidated. The company was to be liquidated. Now, at the time that company was being liquidated, the company owed Solomon. Remember, in this case, Solomon was issued with the debentures in this company. So being issued with the debentures, he was a secured creditor. He was supposed to be paid an amount of 10,000 sterling pounds. Other than the company owing Solomon this particular amount of money, the company owed the trade creditors. Trade creditors, remember, you say that these are unsecured creditors. These are unsecured who? Are unsecured creditors. They were owed an amount of 1,000 sterling pounds. But basically what we said is that whenever a company is to be liquidated, the assets of the company are supposed to be sold. The amount of money which will be received is then supposed to be applied, is then supposed to be used in terms of paying the debts or the liabilities of the company. And actually, we said whenever the liabilities of the company are to be paid, they should be paid in a particular order. We said the secured creditors should be paid first. Then from there, the unsecured creditors. If some money will remain, the unsecured creditors will be paid last. So therefore, the amount of money which was received from the received by the liquidator after selling the assets of this company, that money was not enough to pay Solomon, who was a secured creditor, and these trade creditors. But automatically, as per the order which I've given, the person who was supposed to be paid first was Solomon. I've said once the assets of the company are sold, the creditors to be paid first should be the secured. Now, there was a problem there because these trade creditors, they argued that Solomon Salmon and this company were one and the same, simply because Salmon was the person managing that business. He was the main shareholder. So they argued that this Salmon and this company were one and the same person. As a result of that, the case was taken to a court of law by Salmon. Remember, Salmon is the plaintiff. This is the person who moved to the court. He moved to the court to sue this company, demanding to be paid first as a secured creditor before these other creditors. So when the case was decided, was heard by the court of law, the court basically decided that once a company has been formed, even if the company is formed by a single individual, that company becomes a legal entity, separate and also distinct from its members. And therefore, despite Salmon being the major shareholder, despite Salmon being the person who was managing this particular business, Salmon was regarded to be, or actually the company was regarded to be separate from who? From Salmon. So and therefore, the court ruled that Salmon had a preferential right to be paid first before these other creditors, before those other creditors. So you just need to remember the fact of that particular case, and then you can experience them in your own word, in your own words, provided you're able to capture the key point of that particular word, the key point of that particular case. So that basically what was required as far as that question is concerned. We move to, I think we will just finish with the part B, and then the other two questions, we will do them tomorrow. Yes, so let's go to part B of the question. Part B of the question, and the question reads, highlight the circumstances under which a person may cease to be a member of the company. 14 marks. So the question came from the topic of membership, and the question specifically was on cessation or termination of what? Of membership. So here we see that there are so many ways through which now a person's membership in a company can come to an end. So many ways. We talked, I think, around 11 ways, around 11 ways through which a person's membership can come to an end. I think as we wind up, can you give me some of these ways through which, if you are a member of a company, how can your membership come to an end? If you are a member of a company, how can your membership come to an end? I need around 10 here. I need around 10 ways through which your membership can come to an end in a company. How can your membership come to an end? Yes, in this case, we talked about death. We also talked about what? We also talked about bankruptcy. We also talked about what? Bankruptcy. Yes, I'm waiting for the other ways through which your membership can come to an end. Aaron, I want to see. Okay. Abdi Nasir, I want to see one from you. Margaret, Martin, Felix, Zido. Yes. So the other one is basically through what? The transfer of shares. The transfer of what? Of shares. So transfer of shares basically is whereby you hold shares in a company, but you have decided to sell all your shares. You have decided to sell all your shares. So once you sell all your shares, your membership comes to an end. I'm waiting for the other ways through which your membership in a company can come to an end. These are just 3. We have around 11 ways. Yes, so we also talked about the liquidation of the company. The liquidation of who? Of the company. So once the company is liquidated, basically your membership come to an end. So cancellation, let's talk of forfeiture. Let's talk of forfeiture of shares. Forfeiture of shares, we said, is the cancellation of shares due to non-payment of the call money. Due to non-payment of the call what? Money. So we can also talk about what we refer as the redemption. The redemption of what? Of shares. You hold shares which are redeemable. They have been redeemed. Your membership comes to an end. Redemption of what? Redemption of shares. So here we also talked about something called rescission. So when we talk about rescission, this whereby, for example, you bought the shares of the company, and when you are buying those particular shares, you relied on a prospectus which was misleading. You relied on a prospectus which was misleading. You relied on a prospectus which was misleading. So if you relied on a prospectus which was misleading, you may decide to pull out of that contract. By pulling out of the contract means that you are returning the shares back to the company, and basically the company refunded the amount of money you had paid for those shares. So the contract comes to an end. So at terms which are fair to all the parties. So then also we talked about the surrender of shares. Surrender of shares is where you hold shares, but you feel that you'll not be able to pay the call money. You decide to do what? To return them to the company. So instead of waiting for the shares to be what? Instead of waiting for the shares to be forfeited. So then from there we also talked about repudiation by an infant. Repudiation by an infant. Remember, in this case, we said under common law, an infant can acquire shares in a company, but we said an infant can pull out of that contract, can rescind that contract anytime before attaining the age of 18 years, or within a reasonable time after attaining the age of what? After attaining the age of 18 what? After attaining the age of 18 years. Yes. The other way through which a person may also cease to be a member of the company. Reduction, Catherine, we have reduction. I think no. Reduction. Hapana, kuna kitu kama reduction of shares. Will that affect your membership? Will that affect your membership? Don't think so. I don't think so. Yes, I think we have death, bankruptcy, transfer, liquidation, forfeiture, redemption, recession, surrender of shares, repudiation by who? By an infant. Repudiation by who? By an infant. Repudiation by an infant. By an infant. By who? An infant. Yes. By an infant. Repudiation, I've said, is whereby an infant under common law pulls out of a contract for acquisition of shares. We have said under common law, an infant can acquire shares, but that contract is avoidable. So such an infant can pull out of that contract. Sasa, yes, I think we have this plus more. Maybe check what is there from the notes. Check what could be missing here. Could be missing here. Yes, I think we stop at that particular point for now. So make sure you also go through the other questions which I've already shared with you, and basically make sure you can be able to answer them, because I've noted that majority of you, I think you have not yet revised well. So make sure you go through those questions. When we meet and we are revising on them, it doesn't look like you are seeing those questions or whatever we are discussing here for the first time. It's something you have already revised on your own. Sasa? Yes. So I think basically we are going to stop at that particular point for now. We continue from there tomorrow as we continue with our revision. Sasa? Yes. So we will finish all the questions which are remaining here, and then we move to the other paper. So therefore, make sure even before we meet tomorrow, you try to go through those particular questions there. Sasa? Yes. So any question before we wind up? Any question before we wind up? Any question before we wind up? Okay, Sasa, I think there is none. So we stop at that point for now. Have a good night. See you tomorrow.